I call the Honourable Member Eugenie Sage.
Thank you, Mr Chair. When the House was previously considering the committee stages of this bill, I made a mistake and said that the bill would allow the Minister to call in medium-sized projects and appoint a board of inquiry to consider them. That was incorrect, and I apologise to the House for the mistake. The bill provides for a 6-month deadline for decisions on medium-sized projects, including ones which are notified for public submissions, but it doesn't provide for a call-in. But I would like to make some comments, Mr Chair, on these medium-sized applications and the provisions around direct referral to the Environment Court in clauses 13, 14 and 15. Because the Green Party opposes these provisions as being anti-democratic and reducing public participation. Because the bill enables applicants for medium-sized projects above a yet-to-be-defined investment threshold to avoid a council-level hearing and refer a matter directly to the Environment Court, and it removes the relevant council's power to decline that request except in exceptional circumstances which aren't defined. And an Environment Court hearing is by its very nature much more formal and prescribed than a council hearing. There are a lot more lawyers, there are a lot more people in suits, it's more expensive, and this constrains the public right to participate because of that expectation that people will have legal representation. And Mr Chair, this focus on the value of investment as being the threshold for direct referral to the Environment Court and putting the application on a decision-making track that's quite different is putting the economic value of the application ahead of the public's right to participate and be involved in the decision on whether that application should be proceed. And it's a very arbitrary threshold for an act that is supposedly based on effects. And it's not a good determinant of the complexity of an application nor of its potential effects. And as Greenpeace noted in its submission, it's often a project which has higher economic value will often have many more effects and more serious effects than one with a lower value. So potentially you should be encouraging public participation on those more complex projects, not restricting it by this direct referral provision. And it's definitely eroding the power of councils and local authority decision-making to say that this is mandatory and that they can't decline consent to direct referral except in exceptional circumstances. There's also a risk, Mr Chair, that it will impose significant workload issues on the Environment Court by having more applications go directly to it. But we're also concerned with a number of other provisions in this bill which affect and seek to restrict public participation. One of those is in clause 49, and that's because it introduces this concept of a person who is directly affected by an effect and can restrict participation in the Environment Court to parties who are directly affected. And often, Mr Chair, that's been defined in relation to people who've got a private property interest, such as a neighbouring landowner, rather than a community organisation representing an aspect of the public interest. So this clause is quite a noxious clause and, in our view, a very unacceptable restriction on public participation and access to justice. And I think, Mr Chair, what we're seeing here is the government being quite contemptuous of our international treaty obligations. At Rio +20, New Zealand and more than 190 other countries adopted the Future We Want Outcomes document. That document says at paragraph 43, and I quote, "We underscore that broad public participation and access to information and judicial and administrative proceedings are essential to the promotion of sustainable development." And that builds on very similar commitments in the Rio Declaration in 1992. And the bill is trampling on that because of clauses such as clause 49, but it's also because of the major push in the bill to be quite restrictive around timeframes. And that is all about providing certainty for applicants, but not for the community or the environment which is affected by those applications. And the National Party and the big corporates have run a very deliberate campaign of misinformation about the RMA and about decision-making under the RMA over recent years. We've heard time and time again, Mr Chair,
Eugenie Sage.
Thank you, Mr Chair, talk about the costs and uncertainties and delays from our government members, but they don't talk about the cost to the community or the environment through speedy decision-making. And that's because the National Party is focused very much on the short term. It doesn't understand that if you want a smart economy, you need to underpin that with a healthy environment. You need to look out 50 years ahead. You need to recognise the importance of the ecosystem services that nature provides, clean air, clean water, and the need to safeguard those services, not just by rubber stamping development like mining and drilling and big development along the coast that cuts across those. So there are major parts of this bill and the whole thrust of the government's changes to the RMA in this bill and the proposed bill that's to be introduced later this year, where the National Party is sabotaging our economy because it's undercutting and trampling on environmental quality. And at a time when we should be giving integrity to our 100% pure brand, instead the government is weakening our environmental law rather than strengthening it, which would help give integrity to that brand. And at the moment, this is all about pushing through applications and changing the deadlines. In the Act at present, we have timeframes for specific parts of the decision-making processes at council level, but there's not a set period of time in which a decision should be made when it's made at the council level. And there's a very good reason for this. Often, applicants will change some of the aspects of their application in response to the concerns raised by submitters through the whole process. But the bill is imposing a 6-month deadline on councils to consider and decide medium-sized applications. That compares to the 9-month deadline for applications going to the Board of Inquiry. We oppose that, like Local Government New Zealand, because we are not convinced that there is a problem with timeliness in the Act. When you've got the Ministry for the Environment's own survey of local authorities in 2010-11 showing that 95% of all applications are processed in accordance with the statutory timeframes, that 87% of the notified applications were processed on time and more than 99% of applications are approved, there is not a major problem with timeliness. Certainly the national members pull out anecdotal examples of small applications which may have taken a while, but there's no solid policy analysis in the regulatory impact statement to support this restriction on making the decision within that 6-month period. And it's not good enough, in our view, to beat up on councils, because when the Waikato Regional Council analysed their data about when the timeframes in the Act were exceeded, one of the most common reasons was that applicants could consult with interested or affected parties after they'd lodged their application. And it's again those submitters raising issues and the applicant responding. So as Local Government New Zealand said, the bill is trying to legislate for good practice. This is inevitably difficult and arguably pointless when that practice cannot be validly prescribed in detail because a single practice will not be universally applicable. And, Mr Chair, the deadlines that the bill is implementing are very complex. They will make the Act more difficult to administer rather than simpler, which is supposedly what this government's agenda is about. But by controlling the time frame in this way, what the bill is doing is pushing councils to rubber stamp applications, to not consider their effects appropriately, to not go and subject those to good scrutiny, but instead just to push applications through as if the council were a sausage factory, and to actually restrict the ability of communities to engage properly. Because under the bill, applicants will be able to ask for extensions and for the clock to stop in terms of the processing, but council will only have one opportunity to stop the clock and ask the applicant for further information. And often those requests for further information come in response to submissions from the community and the public where they say that these issues are important to us, these environmental effects will occur, the applicant has not considered those properly, hasn't done an adequate assessment of effects. But by having the mandatory 6-month deadline for medium-sized applications, by having these restrictions on the council asking for further information, it's going to lead to applications being rubber stamped.
Raymond Ho.
Thank you very much, Mr. Chair. I'd like to